Honourable Member for Nelson.
Thank you, Mr President. And I think I can remember where I got up to, which was right at the beginning here, saying that I rise to move debate on motion number 3 on the notice paper under my name. Mr President, the responsibility for any parliament or government is to consciously put in place rigorous protections for the human rights of its community, and it's a weighty and significant matter for debate. It's probably one of the most significant matters for a parliament upon which to focus its collective mind, in fact. To place this motion within a broader human rights context is to go back to the birthplace of the back to the birth of the Universal Declaration of Human Rights, the UDHR. Rebirth often follows decimation, Mr President, and so in the aftermath of World War II, on the 10th of December 1948, the General Assembly of the United Nations adopted the Universal Declaration of Human Rights. As one of 8 nations involved in drafting the Universal Declaration, Australia at the time was a proud driver of the UDHR under the influential leadership of Dr Herbert Vere Evatt, the head of Australia's delegation to the UN. In 1948, Dr H.V. Evatt became President of the UN General Assembly. That same year he oversaw the adoption of the Universal Declaration. Additional to the range of international treaties, global human rights framework, the UN and human rights advocates have emphasised not only codified human rights and policy frameworks which stem from the UDHR, but also the specific role parliaments have in designing their protections, scrutinising their implementation and protections. The Tasmanian community is quite aware of these opportunities and responsibilities of its parliament. Hence the largest number of predominantly supportive submissions made to the initial 2007 TLRI report. Mr President, clauses 1 and 2 of the motion before us cite both the TLRI 2007 and the TLRI 2024 update reports investigating the need for legislative protections of Tasmanians' human rights. Time constraints mean I'll not be able to discuss in detail either of those substantial and detailed reports. Instead, I hope members have informed themselves of these significant reports' findings and recommendations, including the researched and proposed list of absolute and non-absolute human rights recommended to be recognised and protected in the Tasmanian Human Rights Charter. However, for the purposes of this brief debate, a brief summary of the key themes is relevant to the content and intent of this motion. One significant consideration is, what do Tasmanians think of the issue of a legislated Human Rights Act? When releasing its initial 2007 report, the TLRI noted that the public consultation saw a record 407 submissions received from individual citizens and organisations, the largest number of original submissions received on any project undertaken by the Institute. And further, the vast majority of those submissions, 94.1% to be precise, supported the enactment of a Charter of Human Rights. Although the 2024 review of the 2007 report did not hold a further public consultation process, which is explained in the executive summary of the 2024 update report, the review itself was instigated by individuals and representatives of Tasmanian NGOs anxious that the time delay since 2007 may mean the report had dated and slipped behind current human rights policy and framework developments. So, Mr President, what had changed between 2007 and 2024? In 2007, the TLRI made 23 recommendations and found a legislated Charter of Rights would provide a single comprehensible statement of the fundamental rights applicable in Tasmania. It would foster community awareness of human rights and would encourage the systematic development and observance across all arms of government of processes responsive to human rights. The TLRI's 2024 update report did not consider those broad considerations to be outdated. Instead, it reiterates their consistent and growing relevance and need. Further, the 2024 update made 21 recommendations, all of which either supported or extend the original report's 23 recommendations. The update review states, and I quote, "The experience in Tasmania and other jurisdictions since 2007 points to the continued need for a comprehensive human rights framework. Accordingly, it remains the view of the TLRI that there is a need for a Human Rights Act for Tasmania in seeking to protect human rights, develop a human rights culture across government, and to frame parliamentary debate. A human rights enactment provides a consistent and transparent framework for discussion of human rights implications in the development of policies and legislation, as well as their implementation. It also helps frame relationships between the community, individuals, public authorities, legislators and all arms of government, Parliament, the Executive and the courts and tribunals. Accordingly, the TLRI maintains its view in relation to its key recommendations in the 2007 final report and makes further recommendations with a view to strengthening some recommendations. End of quote. That's from the Executive Summary of the TLRI Update Report 2024. And in coming to that conclusion, Mr President, the 2024 report examined interstate legislative developments, review of the established legislation of the ACT and Victoria, for example, and the relatively recent Queensland Human Rights Act. It sought to measure how those acts helped protect, or otherwise, the human rights of those communities against contemporary policies or events, such as COVID-19 and its associated health restrictions, or juvenile incarceration rates and treatment, or access to affordable and livable housing, as examples. In that regard, a key development reflected in the 2024 update report is the fact much of its research and findings are embedded in evidence-based examinations of real-life experiences and scenarios. Crucially, the specific rights identified for enshrinement in law by the 2007 TLRI report are reiterated in the 2024 update, which again recommends, and I quote, "The specific rights outlined in the 2007 final report, recommendation 16, should be adopted in a Tasmanian Human Rights Enactment." End of quote. Those specific rights are detailed in Appendix A of the 2024 report, pages 90 to 91. Mr President, another common theme reiterated across both TLRI reports and their respective recommendations is the potential for legislated human rights to actively influence and improve governance decisions and the culture which both informs and reflects those decisions. The 2024 TLRI report states, and I quote, "While the absence of a single dedicated human rights enactment in Tasmania has not meant that human rights are not considered in the development of legislation and policy or the decision-making processes of public authorities, the TLRI's view is that a legislated mandate to require the evaluation of proposed statutory instruments for compliance with human rights would be a key mechanism to embed consistent approaches to human rights in Tasmania." End of quote. We're told that by finally taking action and implementing the recommended Human Rights Act, we can turn around the current situation which is described by the TLRI, and I quote again, "The approach to human rights in the development and implementation of Tasmanian law and policy since the 2007 final report has been uneven, with variable results for the protection of human rights. Some legislation with the potential to affect human rights has been subject to detailed review, whether by a parliamentary committee or independent review, while other legislation with potential human rights implications has not. This reflects an inconsistency in the evaluation of the effect of proposed legislation on human rights and a lack of transparency as to how human rights were taken into account." End of quote. Mr President, there's no good reason to ignore this expert advice. There's no justifiable reason to keep turning our back on strengthening consistency and transparency in our governance, decision-making and legislation. In this context, it's also important to note the 2024 report's emphasis on the proposed Human Rights Unit, the Parliamentary Human Rights Scrutiny Committee, and for subordinate legislation to be accompanied by statements of human rights compatibility and subject to the usual disallowance procedures where non-compliance with human rights is identified. This truly would highlight and integrate human rights consideration in decision-making processes, while also providing accountability and transparency of those decision-making processes and outcomes. Mr President, I now wish to turn briefly to Clause 5 of the motion before us. As Subclause 5A details, there have been 17 years between the 2007 TLRI report recommendation that Tasmania legislate a Charter of Human Rights and the update report released in April this year. The TLRI does not make such decisive and detailed recommendations lightly or on a whim. Anyone who has taken a cursory glance through either of these TLRI reports would agree rigorous examination and analysis informs and supports both reports' respective findings and recommendations. Which begs the question, Mr President, does anyone really think that if the government continues to ignore these two sets of detailed recommendations calling for a legislated Human Rights Act, that the TLRI will change its mind? That future reports and reviews will suggest something different, whether in another 7 years' time or even another 17 years' time? I think in all likelihood, the calls for action to address the identified need to promote specific, better and accessible protection for human rights would have grown all the more loud and insistent. Another reason why it's inexcusable to wait another year, let alone another 17, Mr President, is unlike some recent examples, the drafting and introduction of a Tasmanian Human Rights Bill will take some time and considerable community consultation and engagement. This motion states a draft bill needs to be developed in accordance with both TLRI reports' recommendations, which includes recommendations number 21 of the 2024 report. And that one reads, and I quote, that a phase-in period be created as part of the operation of the Tasmanian Human Rights Enactment. The phase-in period should be over a 2-year period. So, Mr President, for those frustrated already by the lack of action on a Tasmanian Human Rights Act, this recommendation may at first only add to that frustration. However, development and implementation of a thorough, comprehensive and effective human rights legislative framework will not be a fast process. So we need to start sooner rather than later, which is also why Clause 5, Subclause 5, calls for a commitment by government to introduce a bill within this term of Parliament. The wording of this subclause also recognises that it is beyond the control of the government to guarantee passage of a bill, but that it can undertake to develop appropriately, consult genuinely, and then introduce a bill into the Parliament. It's not an unreasonable expectation, Mr President. It's also worth reminding people that this House has already voted in support of progressing a Tasmanian Human Rights Act. Specifically, the motion passed on the 22nd of November 2022 called on the Tasmanian Government to mark the 75th anniversary of the Universal Declaration of Human Rights, which occurred in 2023, by initiating consultation on a Human Rights Act for Tasmania. The current motion is consistent with and builds upon the sentiment of that earlier vote, which was supported here. Mr President, I mentioned the 2023 75th anniversary of the Universal Declaration of Human Rights. That was the context of the previous vote by the Chamber in late 2022, recognising that actively progressing a Tasmanian Human Rights Act during such a profound anniversary would be a meaningful manner by which to acknowledge and commemorate the groundbreaking Declaration of Human Rights in 1948. Despite the majority of this chamber being willing to seize the historic moment 2 years ago and see progress made, unfortunately the government failed to act on that momentum. I want to highlight briefly the intent of the year-long commemorative project instigated by the United Nations in recognition of the Declaration's milestone, the 75th anniversary project, as it relates to the question currently before the chamber. As stated by the UN Office for the High Commissioner for Human Rights, and I quote, "The 75th anniversary of the UDHR was the moment to rekindle the hope of human rights for every person, a year of commemoration of one of the world's most groundbreaking international commitments. In 2023, we reinvigorated the Universal Declaration of Human Rights, showing the ways it meets the needs of our time and advancing its promise of freedom, equality and justice for all. The year-long focus, which included a range of international events and forums, identified critical themes spanning a range of economic, social, cultural, civil and political rights for the implementation of the Declaration, as well as the rights to development and the environment. A specific call the UN made during that year was for signatory states and subnational states to look at formal parliamentary recognition and integration of human rights." So, Mr President, we are closing in once more on the annual anniversary of the 1948 Declaration of Human Rights, with International Human Rights Day on the 10th of December. The 2024 theme is Our Rights, Our Future, Right Now. International Human Rights Day aims to celebrate the groundbreaking global pledge, but also provides an opportunity for countries, parliaments and governments to reaffirm their commitment to these important principles. to recognise our responsibility to promote these rights for all peoples. Our rights, our future, right now, Mr. President. Significantly, the power of this anniversary recognising the Human Rights Declaration are reflected by other awareness campaigns, such as the current 16 days of activism against gender-based violence, which is deliberately designed to overlap with Human Rights Week due to the natural synergy between the two topics. It's worth noting here how those Australian states with legislated human rights acts will be celebrating and commemorating International Human Rights Day this year. The ACT Human Rights Commissioner is focusing on human rights in housing, with forums and discussions focusing on what role does housing play in giving children stability, reducing family violence, allowing effective rehabilitation, preventing recidivism and promoting good health. And also, how do ACT laws need to change to better protect the right to housing? The Victorian Equal Opportunity and Human Rights Commission will commence a week-long range of activities in partnership with that state's 6 independent commissioners to also highlight, educate and reinforce Victoria's human rights laws. Queensland is celebrating the 5th year of a jurisdiction with legislated human rights protections by reflecting on what the Act has meant for Queenslanders and how that state can look to protect and strengthen it into the future to truly embed a human rights culture. We here now could position Tasmania and our fellow Tasmanians to be in a similar position where in 2 or 3 years we could celebrate International Human Rights Day by also celebrating our new Tasmanian Human Rights Act. So in conclusion, Mr. President, the 2007 TLRI report found that current protections afforded to Tasmanians' human rights are fragmented and are disjointed and incomplete. Even for those with legal expertise, working out what rights are protected in Tasmania, when and how, is a complex task. Further, that initial report stated, and I quote, "Neither the Australian nor the Tasmanian constitutions represent a comprehensive source of human rights protection for Tasmanians. In fact, they contain few such protections, and those protections have generally been narrowly interpreted by the courts. Many basic rights, such as freedom of speech, the right to a fair trial, the right to life, the right to liberty and security of the person, and the right to privacy and protection of the family, find no mention in our constitutions." End of quote. These 2007 findings were then reinforced by the TLRI's 2024 update review, which found a Charter of Human Rights or a Human Rights Act should be adopted and an independent Human Rights Commissioner appointed to better protect Tasmanians, and that, I quote, that there is a need for a Human Rights Act for Tasmania in seeking to protect human rights, develop a human rights culture across government and to frame parliamentary debate. The role of parliaments, Mr. President, and legislative human rights frameworks is a consistent theme across both the TLRI reports and other reports and assessment of such laws when it comes to fostering and entrenching human rights cultures across decision makers, independent entities, the public and private sectors. These laws have been found to make a positive difference when it comes to respecting and protecting human rights equitably for both the powerful and the vulnerable. There's no excuse for continued legislative procrastination in this state on this matter, Mr. President. The UN International Human Rights theme for 2024 is our rights, our future, right now. So on the dawn of Human Rights Week and in the lead up to International Human Rights Day on the 10th of December, now is the time to commit to both the commencement of drafting a bill for the long recommended Tasmanian Human Rights Act and to commit to introducing such a bill during this current Parliament. And on that, Mr. President, I commend the motion to the House.